This week for our Toil and Trouble employment law slot, I'm joined by Duncan Cottrell, Senior Associate, Jeremy Ansell. And Jeremy, we start with a chocolate bar and a woman who took offence at Whitaker's chocolate bar wrapper in Te Reo Māori. She wrote about her dislike of this label and was dismissed from Bluebird. Now, is that legit, kosher?
She wasn't dismissed. She's just been suspended at this stage. But okay. It's a very interesting case, and so peeling it back, as you say, she wrote a comment online in quite negative terms about the Whitaker's promotion, which was to label their chocolate bars in Te Reo Māori. She wasn't particularly complimentary towards the initiative. She made comments along the lines of, this is pushing Te Reo down people's throats. Now, she didn't make it on a work account or anything like that. It was made in a personal capacity on a personal Facebook page. But unfortunately, what happened was some person on TikTok, a different social media platform, found that comment and then created a video which sought to try and shame this person, and also drew the connection between her and Bluebird, the employer. So that has obviously raised in that employer's mind a question of, have they been brought into disrepute by this person's comments.
Right. It is a bit of a grey area though, isn't it? I mean, and we've seen this before with vaccine comments or anti-vax or anti-COVID-19 response things. Employers are a bit minded to watch what's going on social media, aren't they?
It's a really interesting area. The general rule is that for an employer to take action, either a suspension or ultimately a dismissal in relation to an employee's out-of-work conduct, including social media postings, there does need to be some nexus between the conduct, in this case it's the comment, and the impact on the employer's business, or on whether it's on the employee's ability to discharge their duties effectively. A potential issue in this case, and bear in mind that it is just a suspension at this stage, not a dismissal, but if it went down that path, one potential issue would be that the nexus to the employer has not come about through anything that the actual employee's done. They've written a comment on social media in a personal capacity. The person who's drawn the nexus between in this case Bluebird and the comment is a third party who's gone out and created a video. So I do think that raises some questions of whether it would be appropriate to discipline an employee who just writes a comment in their own personal capacity about a matter, but it then, almost through no fault of their own, ends up in the public domain. I think that poses some issues.
Could there be more of an issue if that person has a customer-facing role, for example? If they're on a manufacturing line, does it matter?
That can matter. The role that the person has is certainly relevant. For example, many years ago there was a case involving an employee down south who was involved in a road rage incident, and that employee had quite a high-profile role within the company. They were often involved in media commentary on financial matters, so that was one of the factors that was relevant in that case, the fact that the person had a public profile. I don't know enough about the employee in this situation to know what exactly type of managerial role she had, but
right.
It certainly can be a consideration.
Interesting. And just finally, the third person in this triangle, the
yes.
one who doxed her, outed her, does that person have any legal ramifications to their behaviour at all?
Well, not in an employment context that I can see. I don't know who this person's employer is, but just on a moral sort of level, there's something that doesn't sit quite right about it, isn't there? I mean, the fact that there are people out there who obviously go and look for contentious comments online and then set out to shame the individual and find out who the employer is and then create a nexus between the individual and the company. I think that's a bit of a slippery slope. But to answer your question, I don't know whether there will be any employment consequences for this individual, but they themselves could do something via their prolific TikTok account that might eventually bring their employer into disrepute. Who knows?
I mean, if you want to troll Twitter for outrageous comments, you could do it all day long, couldn't you, and be a full-time job?
Absolutely. And do we want a society where people have to completely anonymise themselves online for fear that somebody discovers who the employer is and tries to get them into all sorts of trouble?
Yeah, absolutely. Now, moving to a different issue, Gaurav Sharma, who this week was suspended from the Labour Party or kicked out of the caucus. This does have an employment law ramification. Can you just explain that?
Sure. So firstly, just to point out, it is this happened obviously in a parliamentary setting. So Gaurav Sharma is not an employee. The Office of MP is a statutory role, so that's important to bear in mind. But there were all sorts of issues that came up in this matter that could very easily occur in an employment context. So, for example, you had an MP raising allegations that his staff were not up to scratch and were incompetent. We see that often, managers raising issues with employees about that sort of thing. You then had some employees raising concerns about the way that Dr. Sharma was managing them in the parliamentary setting, again, something that we see in an employment context. And then you had Dr. Sharma raising allegations about the Labour whips and their behaviour. That's obviously relevant to Parliament only, but you quite often get these situations in any workplace where you've got multiple parties, multiple allegations being raised, and the employer is in a difficult position because they then have to assess who's saying what, who's alleging what, and assess the credibility of various claims.
So, stupid question, but does employment law apply equally to parliamentary services?
Parliamentary services employs staffers, not MPs.
Right.
So it's almost a triangular relationship where staffers, for example, comms people within Parliament, they're employed by parliamentary services, but parliamentary services don't have oversight over the day-to-day running because the staff obviously report into the MP. So that is quite a unique relationship involving three parties.
So given that we don't really know what's gone on here, we don't really know the extent of whatever he's done, the staffers have done, or parliamentary services have done, what can we take as a lesson from this? What can employers take?
I think any employer facing a situation like this where there's various people making claims, multiple parties, they should seriously consider whether it's appropriate to bring in somebody external to investigate those claims. And there is a difference between an investigator for a matter like this and a decision maker. So quite often what happens is an investigator comes in to assess the various claims and establish facts. They then produce a report to the employer. They then step out of the process, and the employer appoint a decision maker to effectively take that forward. They decide whether there's grounds to raise disciplinary allegations, etc., and the employee might suffer consequences as a result of that. But I think the lesson to learn from this for any employer is if you've got a matter that involves a whole lot of different parties, potentially serious allegations, and it's difficult to have somebody within the company who can remain impartial and who's far enough removed from the matter and the parties to be free of bias. If you can't do all of that, then it's a good idea to potentially look at getting a third party in to assess the claims. And there's multiple licensed investigators out there. Lawyers from law firms do it as well, so lots of people you can call upon to assess those types of claims. It's
surprising that the Labour Party hasn't called in someone to look at this, I think, but
I mean, that's an inherently political decision, isn't it?
Yeah. Now let's just talk finally about Etu versus Carter Holt Harvey. Can you just explain what this case is about?
Sure. So this is a case relating back to the first lockdown in March and April 2020. And what happened in this situation was the employer forced a number of employees to take annual leave. So what they said was, the lockdown's about to start. For the first couple of weeks, we're going to pay you, but after 14 days, you're going to be required to use annual leave. And then if you don't have that, other forms of leave, and eventually it could become unpaid. So in order to declare that to their staff, they sent out an email and a text message communication. All of that happened on the 23rd of March 2020. The significance of that date is because it's the date at which the lockdown was announced. So clearly a rushed process, and I certainly have a degree of sympathy for the employer because they've been put in an extraordinary situation and they've kind of rushed their process and maybe didn't know how to deal with it. But 3 of the employees joined with the relevant union, and they then took a claim to try and get a declaration that the direction to take the annual leave was made unlawfully. And eventually it went to the employment court. It was removed there as an important question of law, and the employment court decisions come out recently, and it's held that the direction to take that annual leave was unlawful.
Now, to me, this just seems, and I know you've expressed some sympathy with the employer here, but right from the beginning, employers were told that there would be money available to them to pay employees who took time off. So I just don't understand what the justification is for saying this kind of thing.
Sure. So again, the timing's important. So this direction to take leave was issued, as I said, on 23rd of March. At that stage, there was rumblings about a wage subsidy coming into place, but nothing had been confirmed. So the employer's obviously worried about the impact on the business, because this wasn't a business, this particular manufacturing logging plant, it wasn't a business that was able to operate under level 4 conditions. So they're obviously worried about the impact on the business. But the key issue in the case was that they skipped the consultation part. They tried to say that, firstly, that it was going to be too rushed, there wasn't sufficient time to do the consultation. Secondly, they tried to argue that it was a foregone conclusion what the result of the consultation would have been. They tried to say that it was obvious they knew their employees wouldn't want to take annual leave during that period, so basically why bother? And that argument was dismissed by the court, and the court found that you do actually have to, before you issue a direction to take annual leave, you do have to try and seek agreement with your employees on when that leave's going to be taken and iron out any issues there first.
Do you think in any situation where there is a lockdown ordered by the government that it would be acceptable to try and get your employees to take annual leave? Or is that just such a exclusive and strange situation that it would not apply?
No, it certainly could, but the key thing again is the consultation. So you don't have to agree with what your employees say. So this employer, Carter Holt, they didn't have to agree to not force employees to take leave at a certain period of time. That wasn't the point. The point was they never put it to them as a proposal and genuinely considered the feedback. But as I mentioned, although it's a lockdown case, this is completely relevant for employers going forward, because who knows what other situation may arise in the future. And the key lesson is take a step back, pause, perhaps consult legal advice, think about what you're proposing and make sure you tick the consultation box and put the proposal to employees and consider their feedback in a genuine way before you send out a confirmation of that decision.
So what you're telling me, though, is if there is another lockdown and the employer goes through all the consultation and the employees say don't take our annual leave, and they go, no, we're going to do that. Are you saying the employer might still be in the right in that situation?
Well, employers do have the ability to direct annual leave, so that's set out in the Holidays Act. But you do have to try and seek agreement first. It's not normally an issue because there's also a period in the Holidays Act relating to close down periods, and that's what a lot of businesses have, around Christmas time every year, and that's a different issue. But that's normally when employers will require staff to take annual leave, and they don't normally try and do it at other periods of the year. But obviously, because of the extraordinary situation with COVID, there were a whole lot of employers around that time who did issue these types of directions, and as you can see, the wheels of justice take a long time to come through, and the decisions are coming through at the moment, and this one's not gone in favour of the company in this instance.
Jeremy, thank you very much for coming in and talking to the NBR.
Thank you.